Hello everyone, this is Sam with Child Support Game Over. First off, thank you guys for tuning in and watching this video. I believe it's very important. The information that I'm going to share with you is very important in regards to dealing with your family law issue, as they call it, paternity matters, etc., child support, etc. First and foremost, I'm not a lawyer. This is not a law firm. Please do not take anything that I say and construe it to be legal advice. I'm just sharing with you my research and my studies so that you can come up with your own conclusion and possibly do it in your own state to understand that these so-called courts are not constitutional courts. Okay, and there's a lot of videos out there, guys. Yeah, you know, it's all true that the state is a corporation, so it's de facto and there's really no legitimate courts. But if they want to try to claim that they're operating under the constitutional powers as far as the judiciary goes, I'm going to prove to you that they are not. And at the very best, the courts are quasi-judicial entities at best. Many of you know that in order to have or be in an actual Article 3 court, the judge has to have lifetime tenure, such as the United States Supreme Court, which is independent. It's a creation of the Constitution, and therefore it is independent, and it derives its power from the Constitution and not from Congress, and in your state, not from legislators. Okay? But what are you dealing with? You are always dealing with a legislative court. But let me jump into it, guys. When you're so-called summons to appear in these tribunals, we all must have to understand this paragraph right here, that the common law system was merged with the courts of chancery, the common pleas, the English King's Bench Court. You know, so when you walk into these tribunals, there's a multiple jurisdictions that can attach. Now, if the plaintiff is commencing the action, he's going to invoke one of those jurisdictions, and obviously 9 times out of 10, it's going to be your statutory, right? I can almost say 10 times out of 10, you're going to be dealing with a statutory court, unless a common law action or an action known to common law was brought against you. But in regards to these family law matters or child support or paternity actions, no, they're not bringing you in, obviously, under the common law jurisdiction. Otherwise, you would have a right to a jury trial and your full constitutional rights in those proceedings. So, this paragraph, guys, goes to show you that the united powers of the English King's Bench, common pleas, and the Echo Court and Chancery Court's jurisdiction are also implied. And so what they did in Wisconsin, and it is true in Washington, the state of Washington, that we have in Wisconsin and Washington, the state of Washington has a unified court system. So I'll give you an example of what that is, guys. This is our Wisconsin Constitution, Article 7, Section 2. The judicial power of the state shall be vested in a unified court system consisting of one Supreme Court, a Court of Appeals. This is our highest court in our municipality or political subdivision, and then such trial courts of general uniform statewide jurisdiction as the legislature may create by law, and a municipal court. Now, guys, I'm going to get into the circuit court because everybody in Wisconsin is summoned to appear in the circuit court, and I'm going to show you exactly what this circuit court actually is. Now, this is the constitutional circuit court. Keep in mind, this is the Constitution that I'm showing you. This is not so-called legislative enactment. This is Article 7, Section 2 of the Wisconsin Constitution, and this is a constitutional circuit court it's speaking of here. Here, guys, 753 circuit courts. So the difference between the 753 circuit court and this circuit court is this is the constitutional circuit court, and this is the statutory legislative court called the circuit court. They called it the same name. It's kind of like how they make a mirror image of everything, right? So you got people and persons, right? In here you got a legislative or a statutory circuit court, and then you have a constitutional circuit court. It's a method, in my opinion, of deception, okay? Because when they summons you to appear in the circuit court, we're all under the assumption that we were summoned to appear in the constitutionally judicial circuit court. That is not true. In Wisconsin or in California, all the way in between out to New York, it is the same crap as you're going to see here. Now, 753, you go to 753.061, court, branch, judge. Okay, right here. Now, pay attention to this, guys. In each judicial circuit, each judgeship, which means judge, shall be given a branch number. Each branch constitutes a circuit court. Think about what that's saying here, guys. I'm gonna do it from layman terms here, okay? Each judge who is elected is giving a branch number, and that branch constitutes. It isn't, but they're saying, the legislators are saying, constitutes a circuit court. Now, why would they do this, guys? For obvious reasons. They just created a mirror image. The legislators legislatively just created a circuit court, the mirror image of the constitutional court, right? Now, the constitutional courts, guys, are common law courts. Their power, the constitutional circuit court derives its power and authority from the Constitution. It comes from nowhere else. So here, when they create the circuit court in 753.061, they're saying that, well, here, I'll give you an example. They're going to now, in 753.03, give it the jurisdiction of the circuit courts. Now, listen to what they did here. They took their branch, right, the judge, and they made him the court. And they said, well, the judge constitutes the circuit court. Now, for those of you who don't know, courts are institutions set up by society. Judges are just elected officials who are supposed to be neutral and detached and preside over the proceedings that occur in the circuit court. But what the legislators did, as I just showed you, they made him the court. The man, the woman in the black robe is now the court. So you don't ever have, in Wisconsin or in other places, you don't ever have an order from the circuit court or the superior court or whatever the name of that court is in your state. You don't ever have an order from them. You have an order from the man or woman in the black robe that is sitting in that court. Okay? Look what the legislators did here. Now, I just showed you the branch, right? The judge is a branch, given a branch number, and the branch constitutes a circuit court. And they gave it all these powers, guys. Plenary powers, the issue, the powers of the Constitution have power to issue all writs, processes, and commissions. This is a great big separations of powers issue. What the legislators did, created a mirror image of the Constitutional Circuit Court, and then statutorily, legislatively, gave their institution that they created the same powers as the Constitutional Circuit Court. So this, in my opinion, is a grave violation of the separations of powers. Now I'm going to get into something really interesting here, guys. It's probably going to blow your mind, because I just went over that the judge is the court. And I'll give you an example of that. Here's Department of DCF, stands for Department of Children and Families. In Wisconsin, this is known, or they claim, as the Title 40 agency in the state. Look at what the court says. Court means a circuit court judge or family court commissioner. They are the court. And as most of you guys know, 45 CFR 302.34 says that they must contract with the court. What is the court doing? Their court. Now, it's not what the court that you're thinking, right? This is this legislative created entity. Well, let me get into that. Here, guys, we have the appropriations, okay? Now, this appropriations, if you don't know, the legislators are the power of the purse. So if you look at the federal government level, Congress is the power of the purse, right? They fund programs, just like they fund this so-called Title 4D program in your state. So legislators fund their state agencies and programs. Now, take a look at this. State agency definition. Now, this is the legislative appropriation, which means that the legislators are appropriating money for specific programs within the state of Wisconsin. State agency means any office, department, or independent agency in the executive branch of Wisconsin state government. The legislator and the courts. Guys, did you just hear that? What did I just say? A state agency is the legislators and the courts. Do you see that, guys? The courts are merely an agency. It's right here in writing. That's not me saying it. It's them saying it. The legislators saying this. They even called themselves an agency. So what happens if you're an agency? You guys can look it up. Otherwise, I could have brought it up on here, but it's real simple. An agency only has, at most, quasi-judicial powers or quasi-legislative powers. So the courts have quasi-judicial powers at best. But now, in regards to Title 4D, they're operating under a contract which declares them to be an independent contractor. Okay? Will they ever admit that? Probably not. But even if they want to bring you into their tribunal and try to pull this crap, you could say, well, I always have the opportunity for a judicial review, right? Because if they're saying that you're in a quasi-judicial tribunal, or a court, as they say, then you should always have the ability for an actual judicial review and something very similar to an Article 3 court, right? But they've taken that away. See, they if you go back to this case, they've mixed all these different jurisdictions into our common law court. So if you go back into history, you'll see that we all started with a common law court, but then the King's Bench and the Crown on the Bench and the common pleas and the Chancery courts combined with our constitutional courts. Okay? Now, with this being said, I just proved, okay, that the courts and the legislators are agencies. Okay? They're not these constitutional, derived from their power from the Constitution. If they're an agency, they're getting directions from somebody, directives from somebody or someone, okay? Or something, okay? They're an agency. So now, what does the agency do, guys? No different. This is the circuit court, same thing under the appropriations in the state of Wisconsin, judicial. Guess what, guys? Look at here. Circuit courts. There is appropriated to the director of state courts for the following programs. Guys, what this is saying to you is the courts are a state agency who is receiving appropriation, which is money, from the legislators to operate a program called the circuit courts. So think about that, guys, in a nutshell of what I've just explained to you. We have courts that are not really judicial, that they're created by the legislator, which does not give them constitutional judicial powers. We have them being an agency of the state, and because they're an agency, they're doing programs that are no different than the Title 4D program. It's no different. They're operating a program called circuit court actions, right? They're summoning people into the circuit court. It's a program, no different than Title 40. It's a program. These are not your constitutional courts. Okay, guys? So hopefully you find this video very helpful. Please comment, subscribe. We do have a book for sale. You can find that at csgameover.com. Go ahead and order yourself one of the books. If you need any private assistance whatsoever, you can contact me at CS, C as in Charles, S as in Sam, gameover, the number 2, at yahoo.com. All right, guys, thank you for watching. Have a great day.